So now he's coming back into it. But by the time he got back into it, Mr. Cooper is already, out of the collar, wants to fight, and what goes on now is Mr. Gibson attempting to limit any escalation of that event. Let's go. It's not that Mr. Gibson is in control of him and instigating him anyway.
Do you want to challenge one of them? That shit, you want to challenge one of them?
So people say, look, we all want a riot, essentially. They want you on one. There's one. He thinks, okay, well, maybe just two guys will decide to do this thing that they did before, and it'll be fine.
Isn't he encouraging fighting?
Isn't he encouraging fighting? I would say he's trying to control the situation, but I would also say that even if he is encouraging a mutual one-on-one sparring thing, that is not a crime under Oregon law. And you can trace that through the technical structure of the statutes on solicitation and the prohibitions on fighting and the degree to which they are such minor crimes that the legislature has decided, consistent with the First Amendment, that encouraging someone to fight is not a crime of solicitation. If you look at
Is it aiding and abetting disorderly conduct?
Is aiding and abetting disorderly conduct? I don't think so. I think in context, he is controlling what is going on. He's trying to control what is going on in a way that preserves the order, because Mr. Cooper is determined to have a fight. And we'll see in a minute that he just can't control himself, and it leads to the problem that happened. But it's not something that Mr. Gibson's not in control of Mr. Cooper. Mr. Gibson is trying to prevent Mr. Cooper from inciting crime. In the way, and it's it's a young man thing. Okay, for these two guys to do these things, but in the context, that's clearly what it's about. You can see other things in the tape on that. These people resolve something like men. They shook hands. This is good. This is progress in terms of creating a dialogue between hostile groups of young men. This is the incident that Clark talks about in her declaration, where she says falsely that Mr. Gibson was attacking this woman or had attacked her. That's not what's happening. He's trying to avoid problems with the behavior of Mr. Cooper.
Tonight
coming up to what she thinks is defend this other woman, and that's where everything's going to go wrong in the next 15 seconds.
I got it.
Now, you can't see what he did there, but you'll see it in the other video. So, 15 seconds later, Ms. Clark is lying on the ground. Now, how did that happen? I would suggest that it happens because Mr. Cooper pushed her, because he's still completely wound up, and she goes berserk. She charges him, she charges through this crowd, charges into the crowd of people standing on the far side of the street. By this time, what does this have to do with cider riot now? These are a bunch of people who left the bar and are having something going on across the street. And she charges these people, someone pepper sprayed her, she turns to dodge from the pepper spray, and she gets hit. And we'll watch that from Plaintiff's Exhibit 4/4205. And when you asked about aiding and abetting, I don't think that where there's a whole common law solicitation, you can't premise aiding and abetting on pure speech unless it falls outside the recognized category. Maybe that's a question for the briefing would be useful on, but aiding and abetting is usually some sort of material assistance, not just talking. Yeah. We'll research that further. 4205. So that's what happened. Now, because plaintiffs have made such a big deal about the criminal proceedings, I'd like the court to note that the Multnomah County District Attorney filed an affidavit with this court, which said, and I quote, "Video observed by Detective Trainer shows Gibson physically pushing Heather Clark." And that's what they're talking about. And that's just as gross a misuse of someone attacking someone as you could possibly imagine. He pushed her, he fended off this violent charge that she made in the process of retreating. That was what was going on. And we didn't hear him saying, I'm sorry, because he is sorry. He didn't want, at any point, the demonstrators doing things that, other than this mutual consent thing, that with the two of them sparred. So, to go back to the First Amendment, cases like Terminello, speech may stir people to anger, it may invite public dispute, it may bring about conditions of unrest. But the question is whether walking up with the video to the bar and doing this, the action that's related to the bar, is that something that caused a clear and present danger of such a terrible evil that we should set aside the First Amendment? And I don't think so. I will also say that as a matter of burden of proof and carrying the elements, there's no proof of damages here. Mr. Golden Armstrong says that, well, there was a group that used to sing and they don't come in. But then he also says that he has to sell the whole thing because of his permitting problems and that lots of new people are showing up because of the notoriety. And that doesn't carry the burden of proving sort of tortious damages. That Mr. Golden Armstrong masks up with this gang and it's right there, filming and so forth and so on, and helping people, commit acts of violence, run to the bar and hide and so forth and so on. That's not the kind of case where a jury can find that a tort has been committed against cider riot. And I know he's not perfect, Mr. Gibson's not perfect, but he's concerned about the future of the county. And he's making a lot of other people concerned as well. And you may say he's a troublemaker and so forth and so on. There's lots of rallies that don't have any trouble at all because Antifa's not there. And the trouble that he's causing is, I think, under the First Amendment, the right to pay for a free society. You walk across the street, the federal courthouse, there's the Thomas Jefferson Building right in front of the federal courthouse. The boisterous sea of liberty is never without a wave. And if we shut down people like Mr. Gibson with court lawsuits, I would believe the people who come next are going to take a darker path. I don't want to see, a widespread adoption of the no-face, no-case philosophy. I don't want to see, people on the right deciding that the only way to protect themselves is to start masking up because, they lose faith in whether the First Amendment and all really works. So that's why that's the grant motion.
Thank you. Mr. Chavez, I know that we're getting close to 11 o'clock and I don't want to shortchange you on time, so I'll let you get started, and after we're getting close to about 11 o'clock, you think that you need more time, I'll be prepared to give you more time. It just won't be today. It will be as soon as we can do it, though. And we can go just a bit past 11 o'clock, but not much. Okay.
Now, the court asked earlier what sort of standard we're looking at in regards to both problems, but I'd like to start with problem 2. That's the simplest one for us to resolve here today. Now, while the defendants somewhat made a hash of what standard we're actually looking at in regards to producing prima facie evidence to meet our burden of production under the statute, it's quite simple. It's been laid out in both Young and Handy that essentially it's not to require the plaintiff to prove its case before being allowed to. All the plaintiff has to do is present evidence to the court that shows that a reasonable trier could in fact see that this is the claim that we made in our complaint. There's a lengthy discussion in the Handy case regarding the legislative intent, what was considered before voting on this antislap statute, and as we see, it's about minimal merit. It's not about robbing plaintiffs of the ability, as told in the Oregon Constitution, to be able to bring a case and have a jury weigh the evidence in that case. So when the defendants just spent a significant amount of time trying to present evidence of questions of fact to the court just has to disregard all of it, because what matters is the plaintiff's burden of production. And we have made that burden, we have met that burden exceedingly, both in the evidence that we've provided through our declarations, as well as the exhibits that we've produced, some of which we just viewed right now, and as well as what's alleged in the complaint. And it is indeed an early stage in this litigation, in which case the court cannot view this as a summary judgment motion as is suggested in the briefing by the defendants. This is about production of prima facie evidence. It's as if there was a directed verdict, or it's as if the defendant didn't show up and the court still needed the plaintiff or a petitioner in a backup hearing to be able to produce evidence that the court can then make a ruling on. It doesn't mean that the court can then attempt to use the defendant's evidence to contradict what it is that is in the declarations. It just means that the declarations speak for themselves, and that's the evidence that can be brought. If the defendants want to bring these claims, bring these videos and make the assertions that they do to a jury, they're more than welcome to do that. The fact is, though, they will have to make that to a jury and not to the court at this early stage in the litigation.
What about the example that Mr. Buell raises that in his view, some of the video evidence flatly contradicts the assertions made made in some of the declarations. To the extent that that is true, can't I disregard the declarations?
I don't think so, Your Honor, and I'd like to unpack that in a couple of stages. First, I mean, the cases cited with regard to video evidence being absolutely dispositive are circumstances where there is just flatly refutable evidence. I think I'm blanking on the case name right now.